the biggest reason non-tax related to not buy the building in the S corporation is that if something were to happen to somebody at the building, all of the S corporation's other assets will be at risk. And that's really a legal thing, right? Cash in the S corp bank would be at risk in a lawsuit if something happened at the building to, say, a visitor or a worker. So I generally like the idea of separating real estate from the active work that a company does, primarily for asset protection. And again, that's a legal thing. So I might say that to the client, but I'll be very careful to have asterisks around all of that and advise that they really ask that question to their attorney. Now, from a tax perspective, why might I not want the client to purchase a building in the S corporation? And this is the part I know y'all have heard me preach a million times. We rarely, I'm not going to say never, and we talked about why a couple sessions ago, I think. It's rarely wise to purchase appreciating property in an S corporation. And you've heard me say in the past, never, 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 never own real estate in an S corp. There are one or two exceptions, but it's really wise to purchase appreciating property in an S corporation. And the biggest reason for that is there is no way to get the building out of the S corporation without it being deemed a sale. There's no deed of gift. There's no way around it. Moving that building or property out of the S corporation is going to be a deemed sale, even if no money changes hands. So that's a pretty big reason not to do it. Another reason is there's no step up in basis in that building upon the death of one of the S corporation shareholders. So, if I hold, say, a rental property or my house personally, and I die, my heirs get a step up in basis to fair market value as of the date of death. If the S corporation owns the property, the shareholder doesn't own the property. So the shareholder passing away doesn't result in a step up in basis. Now, there may be some type of basis adjustment for the value of their basis in the S corporation itself, but not the property alone. So that house or that property, in this case, the commercial building, is really held hostage in the S corporation. And that's typically not desirable. Then there's no ability to allocate ownership of that building differently. You're going to see further down, well, we already talked about in this scenario, one of the partners has cash to put towards the down payment. The other doesn't because they have college tuition to pay. There's no way to change the ownership of that building. If it's owned in the S corporation, everything is 50-50. So can an S corp do a 1031 exchange? I believe so, as long as all the proper form is followed. I'd have to double check that. So the answer is I think so, but I'm not 100% sure. I don't think I've ever had an S corp attempt that because we'd have to talk that through. That might be a good topic for another session. So we'll come back to that. So any questions about some of the reasons why I would not advise our client to purchase the building in the S corporation? Is there anything you can think of that I didn't mention? So the primary ones are no way to get it out. It's held hostage, no step up in basis upon death, no ability to split ownership in the property differently than the ownership of the S corp.
Yeah, another thing to think about is in California, just for the privilege of holding an LLC of any sort, you get to pay the state an automatic $800 franchise fee just for the privilege of holding it. And that's on top of any taxes you might owe.
Right. So that might be a reason not to form a separate entity because they'd have a separate $800. Okay. That would be a factor. And so if I were completing a list of pros and cons, that one would go on the con list. So then if I've already come up with a bunch of ways or a bunch of reasons why it's not desirable to hold the business in the S corporation, what would support me recommending having them purchase it in a separate, newly created multi-member LLC? It's really just the positive side of all the negative statements I just made. So there are ways to get real estate out of a partnership without it being deemed a sale. Ownership percentage can be handled differently in a partnership. They can really allocate it any way they want. The S corporation's other assets won't be at risk if something happens, as long as this is properly structured and they observe the formalities of the two separate entities. And then a third one, which we haven't even gotten to yet, is that debt basis or debt partnership liabilities can increase partner basis, whereas S corporation liabilities do not. So if the newly formed LLC took out a mortgage for this building, the partner's allocation of that debt can temporarily increase their basis in a partnership where it cannot in an S corporation. So there's a fair number of reasons, right? Like as I'm conducting this analysis, as of right now, without any further review, I'm leaning towards the multi-member LLC owning the building. Same two partners as the S Corp shareholders, but a lot more flexibility.